Lesson: Structuring a contract document. Structuring a contract document is a fundamental skill for any professional involved in contract law or business negotiations. A well-drafted contract not only serves as a legal safeguard, but also as a clear operational guideline for all parties involved. The process of structuring a contract involves several critical steps, each of which contributes to the clarity, enforceability, and efficiency of the document. This lesson focuses on actionable insights, practical tools, and step-by-step applications that professionals can apply directly to their contract drafting processes. The first step in structuring a contract is understanding the essential components that must be included. These typically encompass the preamble, definitions, recitals, operative provisions, representations and warranties, covenants, conditions, indemnities, termination clauses, and boilerplate provisions. Each section serves a unique purpose. For example, the preamble sets the stage by identifying the parties and the contract's date, while the definitions section clarifies key terms to prevent ambiguity. An effective tool for ensuring these elements are properly structured is the use of a contract template. Templates serve as a foundational framework, allowing drafters to focus on customizing specific terms and conditions rather than starting from scratch. They offer a standardized approach, reducing the likelihood of errors and omissions. However, it is crucial to tailor templates to the specific context of each contract to avoid potential issues arising from irrelevant or inappropriate clauses. Another critical step involves the clear and precise drafting of terms. Ambiguity can lead to disputes and litigation, so clarity is paramount. Utilizing plain language instead of legal jargon enhances understanding and reduces misinterpretation. The plain language movement advocates for contract language that is straightforward and accessible to non-lawyers, which has been shown to reduce disputes and improve compliance. For instance, instead of using herein before, one could simply say previously in this contract. The integration of practical tools such as checklists can significantly enhance the drafting process. Checklists act as a safeguard, ensuring that no critical component is overlooked. They provide a systematic approach to verify that each section of the contract is addressed comprehensively. For example, a checklist for the termination clause might include questions about notice requirements, termination fees, and the rights of parties upon termination. This methodical approach minimizes the risk of oversight and enhances the contract's enforceability. Incorporating a risk assessment framework is another essential aspect of contract structuring. This involves identifying potential risks associated with the contract and incorporating clauses to mitigate these risks. A SWOT analysis can be a valuable tool in this context. By evaluating the strengths and weaknesses of each party, as well as external opportunities and threats, drafters can anticipate potential issues and address them proactively. For example, if a significant threat is a potential delay from a supplier, the contract can include penalty clauses for late delivery to protect the buyer's interests. The use of negotiation strategies during the drafting process is also crucial. Understanding the priorities and concerns of the other party can lead to more favorable terms and a mutually beneficial agreement. The Harvard Negotiation Project's Getting to Yes approach suggests focusing on interests rather than positions, creating options for mutual gain, and insisting on using objective criteria. This approach can be particularly effective in complex contracts where multiple interests must be balanced. In practice, real-world challenges often arise in the form of unforeseen circumstances, such as economic fluctuations or changes in regulatory environments. Contracts must be flexible enough to accommodate such changes without compromising the parties' interests. Including force majeure clauses, which excuse parties from performance due to extraordinary events, is a common strategy. These clauses should be carefully drafted to specify what constitutes a force majeure event and the procedures for invoking it. The COVID-19 pandemic highlighted the importance of such clauses, as many businesses sought to suspend contractual obligations due to government-imposed restrictions. Case studies provide valuable insights into the effectiveness of these strategies. For instance, a study of contract disputes in the construction industry found that unclear scope of work and poorly defined roles and responsibilities were primary causes of litigation. By applying the tools and frameworks discussed, such as clear definitions and risk assessment, these issues could have been mitigated, demonstrating the practical value of structured contract drafting. Statistics further illustrate the impact of well-structured contracts. A survey by the International Association for Contract and Commercial Management found that companies with effective contract management practices reported 9% higher revenue growth and 10% higher profit margins compared to those with less effective practices. This data underscores the tangible benefits of investing in the skills and tools necessary for proficient contract drafting. In conclusion, structuring a contract document requires a comprehensive understanding of its essential components, clear and precise language, practical tools such as templates and checklists, risk assessment frameworks, and effective negotiation strategies. By applying these actionable insights and frameworks, professionals can enhance their proficiency in contract drafting, leading to more robust, enforceable, and mutually beneficial agreements. The integration of real-world examples, case studies, and statistics throughout this lesson highlights the effectiveness of these approaches and underscores their importance in the field of contract law.